Okay, in this video, video number 3, about the new bail reform laws that are coming into effect January 1st of 2017, I now want to address why it is you should retain counsel for you or a loved one or whoever you want to protect who has been accused by government on a warrant complaint of having committed a criminal offense and will be shipped to the county jail for 48 hours of pretrial detention while awaiting a hearing to determine what the terms and conditions of pretrial release will be. That's new lingo for how much bail do I got to pay to get out of jail awaiting trial. Should you be represented by counsel for this? You know, to me, it's a no-brainer. You should be. Because why? Because a judge has to weigh in his discretion what appropriate terms and conditions would be to ensure the defendant appears for trial and ultimate resolution of the case. The pinch is going to come for people who make more income than would qualify them for a free public defender or a public defender, and people who did not commit first or second degree offenses. So the question is going to be, at the end of 48 hours, if and when you get that hearing before a Superior Court judge to determine whether you can be released, and if so, how much money you have to post and how you're going to get that together for the court and what other conditions will be imposed, you probably want somebody's experience to make constitutional arguments for you that you're entitled to a better deal than the prosecutor would like you to have initially. It can mean the difference between, being free on bail or being detained in jail until trial. Now, what you see in really serious cases where someone commits a murder or allegedly commits a murder or an armed robbery or kidnapping or carjacking, which is a violent theft with a weapon, they wait in jail. They can't get bail because the bail is either, $500,000 or $1 million, or it's withheld for the protection of the public. The important point here is the time frame can be a minimum of 4 months, maximum of at least a year. Waiting in jail to be heard. Now, the important thing to fathom also is that, defendants have only been accused. Under our system, you get accused, you have a right to counsel. The state has to prove your guilt beyond a reasonable doubt at a trial, or you have to voluntarily agree that you're guilty and engage in a plea to usually a lesser included offense, which is why a plea is usually palatable if you're guilty. But the gist is, being put in jail first is going to put people in a very tough spot, especially if they're, have defenses or they're materially innocent. So the kind of person that's going to hurt is someone who commits a low level, what I would call a low-level offense. And then the question is going to be, what kind of imposition will government place on you for you to get your freedom, and do you deserve a chance to get the best possible deal to get out of jail? My name is Stephen A. Gravatt. I'm practicing law in New Jersey for 29 years approximately. I've handled many, many, many criminal indictable cases for people, many bail applications. The new law will present new challenges. A lot of it will be procedural. A lot of the substantive law hasn't changed, but many people don't understand what their best arguments are, and they need help. My cell phone number is 732-337-7922. My website is www.njDWIcriminaldefenseattorney.com. If you need a lawyer, I'd be happy to help you with these circumstances. Thank you. Have a great day. Bye-bye.